Fines at the enforcement stage. If a fine goes unpaid past the due date or a person defaults on their payment plan, the agency who issued the fine can lodge the unpaid infringement notice with the Infringement Court. The Infringements Court is where those unpaid infringements are administered. It's not an open courthouse with public hearings like the Magistrates Court. Here's a situation where a young person gets a fine and it ends up in the Infringements Court. Joe is 20 years old and he has an intellectual disability. About 6 months ago, he was sitting on a bench waiting for a train on the platform. He happened to spit on the ground just as a transit police officer was walking past. The police officer stopped and issued Joe a fine for spitting on railway premises. Joe ignored the infringement notice and the penalty reminder notices that followed, and now he's got a letter from the Infringements Court saying something about an enforcement order. Joe got that notice because his unpaid fines were sent to the Infringements Court, and once fines are lodged there, an enforcement order is made by a registrar. Extra costs will be added to the fine, and the person then has 28 days to pay up in full or set up a payment plan through civic compliance. It's now too late for Joe to apply for an internal review with the agency, but he or someone acting on his behalf can apply to have a fine revoked by the Infringements Court registrar. This means asking for the fine to be cancelled. He could make an application for the Infringements Court to revoke the fine on the basis of his special circumstances, and special circumstances mean the same thing as it did at the internal review stage. That is, the person has an intellectual disability or mental illness, a drug or alcohol addiction, or was homeless at the relevant time, and this meant they were unable to control their conduct or understand that they were committing an offence. If Joe or someone else on Joe's behalf applied for revocation to the Infringements Court on the basis of his special circumstances, as a person with an intellectual disability, the registrar there would need some proof of this. The application should include a letter from a doctor or a specialist confirming Joe has an intellectual disability and how that disability makes him unable to understand spitting at the train station is an offence or control himself from spitting. Frequently asked questions. What happens once someone makes a special circumstances application to revoke their fine to the Infringements Court? The registrar would then review the application and they can either do one of three things. A, they can ask for more information. B, they can find special circumstances and refer the matter to the Magistrates Court. Or C, they can reject the application. If the registrar has all the information they need and they find that there are special circumstances, they must revoke the fine. They must then refer the matter to the Magistrates Court unless the agency indicates that they don't want to pursue the matter any further. The fines are then heard in the Magistrates Court in the Special Circumstances list, and the young person will be summoned to appear before a magistrate or a judicial registrar. The list is usually held in a separate courtroom, and there are duty lawyers at court for people who have not had legal advice or don't have their own legal representative. The magistrate or the judicial registrar will then review the application, the support letters and any new material, and the person or their representative can make some submissions. If the magistrate or judicial registrar agrees that there are special circumstances, they can proceed to hear and determine the matter. They can find the matters proven and dismissed, so that no amount of money has to be paid, or they can order an adjourned undertaking where the person promises to be of good behaviour or follow conditions like getting counselling or treatment. What if the Infringements Court registrar finds that there are no special circumstances? You can make a second request, and if you have permission from the Magistrates Court, a third request if you have more information to prove special circumstances. Or you can seek a review of the decision of the Infringements Court registrar to find no special circumstances and ask that your application be referred to the Magistrates Court. Even if they reject your application, the Infringements Registrar has the power to vary extra costs for unpaid fines. Applications to the Infringements Court can be tricky because registrars follow strict guidelines on what evidence of special circumstances they will accept. So it's best to seek help from a legal service like Youth Law, a local community legal centre or Victoria Legal Aid before making an application. If an enforcement order is made against a person and they don't pay by the due date or they default on a payment plan, they can end up in a situation much like this. Fines at the warrant stage. Zach is 23 and he's got about $16,000 worth of outstanding infringement notices dating back to when he was 18. He racked most of them up when he was 18 and he went off the rails with drugs and alcohol after his dad died. He's been a lot better lately because he's been seeing a counsellor and he's even got a full-time job lined up for next month. But a sheriff's officer came to his house yesterday with some kind of warrant and gave him a 7-day notice. If the enforcement order remains unpaid in the Infringements Court, then the registrar can choose to issue what's called an infringements warrant. There will be extra costs added to the fine, and the warrant will give the sheriff's office power to take action to recover the unpaid amount. The sheriff would then direct someone, usually a sheriff's officer, to go and enforce the warrant by going out and fining the person with the unpaid fines. When the sheriff comes to that person's house, they'll ask the person to pay the outstanding amount in full, and if the person can't, then issue them with a 7-day notice, which is what happened to Zach. This notice means Zach has 7 days to take action before a sheriff's officer will come back. If Zach can't pay in full within 7 days, he can ask for a payment plan through the Infringements Court, which may or may not be approved. Or he can apply to the Infringements Court for revocation through the same process we've already outlined. For example, a special circumstances application if he can get a letter from a doctor or psychologist confirming he has a drug and alcohol addiction. If Zach doesn't apply for revocation, or if he can't get a payment plan sorted out within 7 days, the sheriff's officer will come back and take enforcement action. The sheriff's officer has the power to do things like seize and sell off assets, suspend his driver's license or vehicle registration, or arrest him and take him to court. Even before they issue a 7-day notice, the sheriff also has the power to do things like enter a house by force if necessary to see if there's property to sell off, wheel clamp vehicles, or stop people from renewing their licence or motor vehicle registration. They can demand a person show their ID if they suspect that a person has a warrant out, and they can physically restrain anyone who tries to stop them from taking enforcement action. If someone tries to stop them or tamper with a wheel clamp, they may face criminal charges. With property, there are limits on what the sheriff can take. They can't take a person's vehicle if it's for transport only and it's below a certain value. They can't take basic furniture such as fridges, washing machines, lounges and beds, and they can't take heaters or coolers, and they can't take educational items such as computers or tools of trade up to a certain value. Sounds like Zach doesn't have any way to pay off the fines, and he may not be able to get a payment plan approved. If he doesn't have assets to sell off to cover all of the fines owing, the sheriff's officer can arrest him and either release him on a community work permit, release him on bail, or remand him to go before the Magistrates Court. The first option is a community work permit, and that's when you can do community work to the value of the fines that are owing. A sheriff's officer may agree to sign you up for one of these if the person consents and they think the person has the capacity to do the work and to stick to their conditions, and the person owes less than 100 penalty units worth of fines, which is currently $14,084. 1 hour of work amounts to 0.2 penalty units, which is currently about $28 paid off in fines. The permit is managed by corrections, and if you don't keep up with their hours or you commit an offence punishable by imprisonment during the permit, you can be charged with breaching the permit conditions and prosecuted in court. Zach owes too much to be eligible for a community work permit. If he's starting a new job next week, committing to work hours with corrections might not have been a good idea anyway. If the sheriff decides to then bail Zach to go to court, he must attend court or else a warrant will be issued for his arrest. If he does not turn up, he may face a further charge of failing to answer his bail. Once he's at court, he has the opportunity to explain to the magistrate why the fines were not paid, either in person or through a legal representative. Because he's on low income, there are duty lawyers at court who can provide legal advice and representation. The magistrate then has a few options in dealing with Zach. They could actually jail him for the unpaid fines at a rate of 1 penalty unit per day, which is currently about $140.84 per day. Or they may choose not to jail him if they find special circumstances, or they find that jail would be excessive, disproportionate, or unduly harsh. What amounts to being excessive, disproportionate, or unduly harsh isn't clearly defined, so it could refer to situations or circumstances not covered by special circumstances. Here, special circumstances means the same thing as it does at the earlier stages. If Zach has a mental illness like depression, or he has been experiencing addiction to drug and alcohol and he's been seeing a counsellor, he should get a letter from that counsellor or a GP or psychologist if he is one willing to provide that letter. This letter must connect his illness to the offending. If the magistrate agrees there are special circumstances, they can do a few things. Discharge the fines in full so the person doesn't pay anything. Discharge the fines by up to 2/3. Discharge the fines by up to 2/3 and order a jail term to pay off the rest of the fines, or adjourn the hearing for up to 6 months. Alternatively, Zach could argue that jail would be excessive, disproportionate or unduly harsh and refer to things like the death of his father, his low income, his young age and losing his newfound job opportunity. He should get support letters from any workers, family members or friends from the magistrate to consider. If the magistrate agrees jail would be excessive, disproportionate or unduly harsh, they can reduce the jail time, discharge the fines in part or in full, order the person pay by instalments or convert the fines to a community corrections order. The magistrate may also attach an imprisonment in lieu condition to an order to pay the fine or pay it by instalments. And if a person defaults on this, a warrant will issue for a sheriff or a police officer to take that person directly to jail for the remaining amount.